My brother, my sisters, all over the world, all Nigerians, true Nigerians, wherever they today, when I hear my voice, the true Nigeria Oga 23. So make I bring on this story, or make we deliberate time to analyze wetin dey go on for our country. Today, I make I discuss, bring to una notice, which I believe some persons go don see, but just elaborate more regarding our 2023 Nigeria election wey they just hold recently. As una know, say they no go gree. They refuse the election right from the onset because of the malpractices when they think say happen on that day, and which we all know. Election malpractices, vote rigging, people being terrorized, people being threatened all over Nigeria on that day. And many things when it happened that day were made them feel say election when they conduct like that, to the extent when BVAS not fit transmit, and INEC promised, say on that day, they will use the BVAS to transmit result directly to the IRF, and people will get them in lifetime. But that not happen. After not still happen, the chairman still will declare results, and people challenge them right from that very first day. Now we know say wahala dey. Apart from that, we also look at other story when we say senior lawyer Mr. Oluwole Ozazeuze, former director, legal service and voter education, who explained better the game changer BVAS machine, the role that BVAS machine will play in this upcoming case when they go on, as enshrined or explained in the Osun State governorship election when it just passed. Now they take judge the case, and they were able to get a case, you know. Apart from that, we also look at another matter as well when they go on with the interview regarding the election, when senior advocate of Nigeria, Femi Falana, explained, throw more light on the BVAS machine as well. After that, we will talk about how Femi Falana explained about dollarizing Nigerians, where we say anywhere you go, na dollar that they want you to buy many houses. To the extent landlords go want you to use dollar to pay them their rent. Even in most places, if you don't get, you not even see naira, but you go see dollar, which is not, it's not explainable, not in a country, a democratically elected country like Nigeria. So we want to see the benefit of the dollar in Nigeria currently, and looking at most countries of the world when they try to look at how they will come out of dollar, because dollar is already been the legal tender all over the world today. Not really legal tender, but in business. Most businesses, transactions all over the world, they are using dollar as a legal tender. So that's why most countries today, they now come out with BRICS, where you have the Brazilian, you have Brazil, you have the Russia, you have the China, you have India, and you have South Africa come out with BRICS, so that they go use them as a legal tender for trading, so that you can buy the goods in their own local currency, which I think for me, that it will be a good changer if Nigeria can adopt that same means, so that our naira will become valued all over the world. Because apart from Nigeria, they don't get where you will use naira today. So if we can look at that, the benefit of it, if it will favor us, why not? And not see why the incoming government of here adopt such means, and see how we can manipulate or get a favorable currency when we think, if you want to buy oil, you trade with us in BRICS. In a naira, I mean, If you want to sell to you, we sell to you in your own local currency. So we can deal with that. Not say in our own country our oil is bought in foreign currencies. That's why Nigerian naira today is devalued to the extent where we say even in our own country, Nigeria, we can't even see it's more or less valueless. You know, in your own country, they open dollar account, they open pounds account because your country naira have been devalued to the extent where we Nigerians that live in Nigeria start seeing that our own naira is no more valued. Those are the things we will look at today. So we want to see and want to tell me exactly what you feel about it. I hope you not forget to subscribe as you go along and just to give a notification and to share it as well so that people who never know much about these things, they can have a look at it and see how they will benefit them. No, thank you.
I'm sorry, PDP, can you please repeat what you said on the basis of the provision of the law?
I just want to quickly react to the presentation by the chairman on we are in this country and the INEC made a press statement when uploads were not done. You even said there was no hacking of your server and all that. And everyone sitting there is either a Christian or a Muslim. And you know there was problem with uploading your results. Till this minute I'm speaking, many results have not been uploaded on your server. So you cannot be using justification that votes took place at the polling unit when INEC failed in uploading results from polling units. If you had uploaded those results immediately after vote was casted in each polling unit, we will have access to them and I will not be asking questions here. But as I speak to you, those results were not uploaded for hours. Yesterday, I complained to you, the chairman. I complained to 2 other commissioners, and in my presence, they called the rec in Imo, where even the director of ICT was saying they should use offline to upload. So if results were not uploaded, we as parties cannot be challenged that the process is over. The process is not over because it is faulty. Results were not uploaded, and if those results were not uploaded, we are definitely going to contest the authenticity of whatever presentation is being made here. And finally, sir, I want to challenge any returning officer from any state coming here, because there's penalty for you if you lie or if you alter anything. Tell us before you start your presentation that what you are presenting before cameras, that what you are presenting is what is uploaded on INEC website. Please say that and see if you have given wrong information, you will not go to jail.
Okay. Is there any agent of any party that hasn't spoken? Party agent? No, not you. Your party has spoken. Let's give the opportunity to another person. You have also spoken, PRP. Please take your seat. Let's make this orderly, in an orderly manner, please. Speak, introduce yourself.
Mr. Chairman, I'm Chinemelo Uba. I represent APP. I want to align with the submission of the PDP agent. If we take your submission, Chairman, it may seem what we are here for is mere formality, as if all has been done at the level of the ward, local government, and state. Mr. Chairman, if there is difficulty in why what he's saying cannot be done, you explain to us, maybe we understand. But what he's asking for, to my mind, is very apt. We are here as the final collation center, either to correct what has been done wrongly. We've had complaints from the ward, from the local government, from agents there. If we can upload this year, we serve as a final arbiter, so to say. Thank you, sir.
Okay. If you have any complaints, any documents that you may have, please forward them. But otherwise, we cannot be considering the report from Kwan.
Not only of knowledge, but of understanding and history of understanding of institution. Mr. Oluwole Osazi, who's a very senior lawyer and a former director of voter education with INEC. Thank you so much indeed for coming tonight.
Thank you for having me. Good evening.
You came to mind yesterday when that Supreme Court judgment was coming on, and I thought, wow, we had a lot of conversation about the electoral law and what it means for our future elections, especially 2023 elections. Without having to talk about what is happening at the tribunal, because the judgment of yesterday has a huge implication of this particular matter. But let's dwell on what we know and the facts of what has been delivered. This is, we do not have the details of the Supreme Court judgment just yet.
It's not yet out.
But we can extrapolate. Based on what my Lord Justice Agim said yesterday, he was the lead judge, and let's look at what he said. These are some of the excerpts, and I have some quotes from him. He says, it is glaring that the appellants could not prove overvoting.
Right.
That's one of those statements. He also said in that judgment, it is a record in the BVAS machines that can prove the number of accredited voters in a polling unit and nothing else. He also said, the appellant had a primary burden to prove the fact asserted by them in their petition. It is obvious that the appellant's case collapsed. He also said, no evidence was adduced to prove the case of forgery against Adeleke. In the absence of such evidence, the allegation is not proved beyond reasonable doubt. He went further to say that the entire proceedings of the tribunal remain a nullity. He now affirms that on the whole, this appeal fails and it is hereby dismissed. And I dare say the appeal judgment, the Court of Appeal judgment was upheld, which means that there is a relevance of the Court of Appeal judgment, which I've tried to summarize tonight, which we would like you to give perspectives on. But give me an understanding. Some of the statements from the learned judge, honorable judges yesterday, it was a unanimous one from all of the five of them.
Correct, it was. We have to be careful when we are doing an analysis of the judgment because the full reasons for the judgment have not been released yet. But we've spoken to people who were in the court, in the Supreme Court, and who listened to the judgment and who took some notes. So let people know that we are speaking contextually and from what we heard and the records that we have for now in the public domain. Yes, I like the excerpts that you have taken out of that leading judgment. For example, let's take this. It's glaring that the appellants could not prove overvoting. Now, the duty of the petitioner is the duty of the petitioner, and the burden rests on the petitioner to prove his case in the tribunal. If he fails to prove the case, then obviously the election will stand. So he must discharge that burden. And from what was available, that burden was not discharged. Let's take overvoting, for example. They relied on certain exhibits which are certified true copies of the download from the IREV. But the minority judgment in the tribunal said, look, the BVAS machines are here. Rather than take extracts from another platform, let us look at the BVAS machines. It's the BVAS machines that will determine whether there's overvoting or not. Don't forget the definition of overvoting, where the total number of accredited voters, the total number of votes exceeds the total number of accredited voters. That was one of the changes in the new Electoral Act, as we have discussed severally on your program. So having a look at it, the BVAS machine accredits people. It is the device you use for accreditation. So, and automatically it stores the number of people it has accredited. Unfortunately, the majority of the tribunal, now the null judgment, said, look, we will look at this certified true copies given by INEC to the APC as it was that time. They said, no, you shouldn't do that when the machine itself, which is the primary evidence, is before the tribunal. Use that machine. That is the only one that can tell us. Because INEC argued that, well, by the time they uploaded these things, some data was lost, it has not been synchronized. I think that's a word that was used, it has not been synchronized. But good, deal away with those things. Let us see the BVAS machines, the original machines which did the recording. You look at them and look at the total number of accredited voters in those machines. The votes exceed the total number accredited, Supreme Court and the Court of Appeal said no, it did not, and Supreme Court have validated that judgment of the Court of Appeal, and rightly so. If we must state that.
As a rider to that,
Yes.
Mr. Osaziuzi, this is what the Supreme Court said.
Yes.
It is a record in the BVAS machines that can prove the number of accredited voters in the polling unit and nothing else.
Absolutely. That is what the Electoral Act 2022
Where does it
says.
leave IREV?
Look, IREV does not give you the total number of accredited voters. IREV gives you the results. Admittedly, the presiding officer takes the total number of accredited voters that he reads from the BVAS and endorses it in the IREV. It's a human thing. Whereas the BVAS automatically records the total number of accredited voters. It automatically accredits people and records the total numbers. It does not record votes, but the votes as manually filled in is stored in the BVAS and it uploads to the IREV. So it's complementary. What you see in the IREV as the total number of accredited voters should correspond with the total number of accredited voters as recorded automatically by the BVAS machine.
And that is also prevailing in the third prayer in the Court of Appeal judgment.
Yes.
And so this is because basically the Supreme Court upheld the position of the Court of Appeal.
Yes.
And part of the second prayer, the pleading at the Court of Appeal, which Adeleke went to appeal, was that on the issue 3, the question that arose for consideration is whether exhibits SCH1, SCH2, 3, and BVR, that is certified true copies of the forms EC8, A, B, C, D, and E, ought to have been admitted in view of the fact that the receipt issue for their certification possessed the said certification. The court found and held that while the payment of legal fees and evidence of same is an integral part of the certification process, the fact that the receipt of payment was only issued after the certification does not ipso facto render the said public document inadmissible. Issue 3 resolved against the appellant. Can you make sense of that for us?
Well, I think the issue was raised. There was a certification of these result sheets. Yes, a certification, and it was tendered in evidence. Now, when you tender evidence these days, when you tender a certified true copy, you should also show evidence that you paid for the certification of those documents as approved by the issuing authority. So INEC charges you, it's a minimum fee, INEC charges you for certification of each document. Now, when you try to tender these two, you must tender the two together. You must tender the certified true copy of the document you certified as well as the receipt, evidence of payment. So the heavy weather was made of the fact that, the receipts came after the certification, whereas it should precede certification. It should pay before the thing is certified. In practice, different institutions do things differently. What is important is that the certification was paid for.
So it's a procedural issue.
It's a procedural issue. It didn't affect the substance. But they were trying to make it an issue of admissibility. But the Supreme Court said no. You as long as there's evidence that has been paid for, whether it postdated or predated, that should not make too much of it. It's a technical procedural issue. All we need is that evidence that yes, you applied for certification, you paid for that certification, money went into government coffers, and this is the document that was certified for you.
Thank you for clearing that with us.
Yes.
So let's go to this issue 5, which is part of the issue of overvoting that you talked about.
Yes.
This was a position of the Court of Appeal, upheld by the Supreme Court, as was declared yesterday. And basically what you said, I mean, the issue is 5 and 7 were considered together, and the issues raised were whether the petitioners, now respondents, proved overvoting, and whether the trial tribunal was right to have relied on the table supplied by the petitioners to reach a verdict that they provided of overvoting. The Court of Appeal found and held that on the issue of overvoting, the information on the physical BVAS machine supersedes that of the back-end report issued by INEC and which the petitioners relied on. The penultimate court also found that Section 137 of the Electoral Act does not display the need for the petitioner to still call oral evidence of polling unit agents who operated BVAS machines in the disputed unit. It went further to say the Court of Appeal ultimately found that the tribunal was wrong to have reached a conclusion on overvoting based on the content of the table presented by the petitioner and also exhibit VVR, which ought to have been demonstrated in open court. Issues 5 and 7 were therefore resolved and in favor of the appellant. That's Senator Adeleke.
Yes, correct. Again, these are some technical procedural issues which I'm happy you're bringing them to the fore. It has to be broken down so that people understand this issue. You can have a fantastic case, but if you don't go by these procedural steps, then you might have problems in the tribunal. It can apply to either the petitioner or the respondent. Now, the petitioners came to court. Yotola came to court and they look, no, we have an expert, and this expert has analyzed all the data and presented a table of the data. And the tribunal fell into error in relying heavily on that table, which in one sense, the lawyers will understand this is secondary evidence. It was an extrapolated from something else, an extract from another, from the BVAS, from the reports and things. They say, no, the BVAS machine is there. Let us see the printout from the BVAS machines. Rather than rely on this so-called expert, we or anybody can look at the BVAS machines, record the numbers that is there. And it's not enough for you to come and tender these things. People who operated the BVAS have to be there. Documents, to an extent, speak for themselves. But you need to tie those documents. You need some oral evidence to hang those documents and say, look, this is this. We were at this polling unit and this happened, that happened. Some lawyers felt that the new Section 137 of the Evidence Act had relieved witnesses of the burden, or petitioners or respondents of the burden of proving things once you just tender those documents. But from the decisions of the Court of Appeal and the Supreme Court, the documents don't necessarily speak for themselves. There must be some oral evidence tying them and explaining their contents. They don't always speak for themselves. That is my understanding of that part of the judgment.
If you look at all of about the 8 prayers that was taken to the Court of Appeal, the issue of the BVAS is very evident. There's a big lesson that all of us need to learn from the position of the Supreme Court on this issue of BVAS, and it takes me right back into the statement, which for me, it's, yeah, of course, the issue of this is it. Yes, this is it. It is a record in the BVAS machine that can prove the number of accredited voters in the polling unit and nothing else. What lesson do you think everyone, politicians, lawyers, need to avert their mind to, and in fact, Nigerians at large, about the electoral law and our election from this?
Well, the Electoral Act, one of the innovations was that you use the smart card reader or any other technological device, and hanging on that any other technology device, INEC introduced the BVAS. Now, the BVAS, what it does is record the total number of accredits you, of course. And in the process of accrediting you, either through your facial recognition or through your fingerprints, it records it that, look, Mr. Sean has come to vote. That is 1. If Mr. Ozi comes, that's 2. If Mr. David comes, that's 3. It records the total number of people who have come for accreditation. Having come for accreditation, the ballots cannot exceed, not even by 1. If it exceeds by 1, the act says, no, go back, there's something wrong, because automatically the BVAS has recorded and stored this thing. So don't give me any chat by anybody else. Sometimes the back end might be faulty. The main thing is that it is this machine that has recorded these things. Each machine for each polling unit, bring them. And in Osun, they brought them to the tribunal.
If I prove overvoting, what happens?
Now, first of all, before you get to that stage, if INEC realizes, the presiding officer realizes there has been overvoting, when he's entering the results, because first of all, the first thing he does, both the presiding officer and the collection officer, the first thing is to look at the, go back to the BVAS machine, record the total number of accredited voters first, and then you count the ballot papers. If the ballot papers exceed, the votes exceed, you cancel that result. And if it has a bearing on, ultimately, on the overall results, then you go back and conduct elections.
At what point do you reconcile the record on the BVAS? Because, I mean, it's understandable that there are some times that all of what is on the BVAS does not go up, or is not fully recorded, or is not reconciled with INEC owns record because of internet and connection issues.
Yeah, but first of all, it records it there.
Physically speaking.
Physically, it records it there. So that's the first port of call. The presiding officer ought to check that, because he's going to take the number accredited by the BVAS and endorse it into the EC8A, into the result sheet. That's the first thing he does. He will ensure it does that total number of accredited voters. There's a column for that. He records it there. The agents have to take note of that, party agents, and also at the first and every stage of collation. At the collation center, the first thing the returning of the collation officer does is to look at the BVAS and confirm, that's what the act says, confirm that the total number of accredited voters as recorded by the BVAS and transmitted is correct. So it physically checks the BVAS and confirms the correctness before going into the scores and confirming that with the IREV. It's the scores you confirm with the IREV, the total number of registered voters you confirm from the BVAS itself.
Mr. Oluwole, tonight, if there's something that we have learned from the Supreme Court's judgment, which in some way, technically and fundamentally, impact on the electoral law and our electoral process, what would that be?
The importance of the BVAS in the process, the importance of technology in the process. And this has a bearing on the three, I think, presidential petitions out of the LP, Labour Party, or the PDP, and I think the APM, so the 3 remaining petitions. It has a bearing in that regards. But the twist in the presidential petitions now is the fact that the IREV, which was not an issue in this one. So in certain regards, out of the 8 issues, I think 2 or 3 have bearing on not just the presidential, but of course on the overall electoral process and all the petitions that have been filed in this matter. The importance, it's central that, look, you must be careful about this central role that the BVAS plays. And the Electoral Act has come. This is the first time Supreme Court has put a stamp on some of the novel provisions of the Act. So the lawyers are going to sit down, study the judgment. We hope the judgment comes in the next few days, the full judgment. Yeah. We're going to study, dissect it, and see what bearing it has on all the cases and going forward on the operations of the Electoral Act.
I bet you that my Lord Justice, judges at the Court of Appeal will also be studying, all the lawyers will be studying to become something like an appendix to the electoral law for almost everyone. And in fact, eyes will be on some of these statements, which should now be very fundamental and crucial going forward into our electoral process. Absolutely. Thank you so much indeed, Mr. Oluwole Osaziuzi, a very senior lawyer and the former director of voter education. You've been a lot of former. Well,
you brought me here to discuss law, so former director of legal services.
Legal services. Mr. Falana, for staying with us. I was going to ask you, because the Presidential Election Tribunal resumed today. Just before we get into a major conversation, I'd like to know your view, because there are those who are agitated. They went outside of the courtroom today. They were asking that that case should be fully dispensed with before the swearing in of Bola Tinubu. What do you make of that position?
So I think some of our colleagues, with profound respect, are causing confusion. The law is there. Section 285 of the Constitution prescribes 180 days for dealing with election petitions at the Court of Appeal. If there is an appeal, you have additional 60 days. So altogether, you are talking of 8 months. In the case of governors, governorship elections, governorship election petitions, you are talking of 10 months, 180 days in the tribunal, 60 days in the Court of Appeal, and 60 days in the Supreme Court. If people are saying that we should go back to the drawing table, deploy and use technology properly, then we can amend the Constitution to allow election petitions to be disposed of within 2 or 3 weeks. But whereas in this case, the petitioner did not file their petitions until 21 days after the election. So you can't be talking of 7 days or 14 days. But again, as I said, after this exercise, we can go back to the drawing table and amend the Constitution and the Electoral Act to allow for a situation whereby you don't even go to the Court of Appeal. If you are talking of presidential election petitions, as it is the case in Ghana or Kenya, you simply go to the Supreme Court. Up to 2011, governorship election petitions were never handled by the Supreme Court. So I think this experience should really inform some concrete amendment of the Constitution, but that can only be anchored on a proper deployment of technology. And what I mean is that if you have the BVAS machine deployed and you have the BVAS report and results of elections are transmitted to the central server of the INEC. So we should be talking of 2 reports. Those are the reports that should be taken to the tribunal. But in this case, witnesses, the petitioners are calling witnesses. The respondents are calling witnesses. Including the electoral body. After which, of course, The witnesses are going to be cross-examined. It is after the hearing of each of the petitions that the parties will be invited to write written submissions, submit them to the courts, and then have a day to adopt them before the judges will retire to consider the addresses and the evidence led in court. Under the current electoral regime, law regime, you cannot abridge the time. In this case, you are talking of about 5 petitions, 5 election petitions. And every petitioner wants to have a field day in court. So we need to really
Mr. Falana, let me quickly ask you. There was a request by Atiku and the PDP asking the Presidential Election Petition Tribunal to televise the proceedings. The Constitution provides that the proceedings in the court should be a public affair. Well, what do you make of that kind of request based on the interest of the public and the sensitivity of the matter at hand?
No, Sheung, I had expressed my opinion on this matter a couple of months ago. Now, an application has just been made to the court. I cannot preempt the court. I cannot.
Okay. So, I cannot. But Mr. Falana, quickly, because I need to take you quickly on the statement you made today about the BRICS Commission and the dollarization of the Nigerian economy. You have your fear. You think that the IMF and these global institutions are trying to sabotage and have a dominance on our economy. But quickly, based on public interest, what are your expectations of the judiciary in these proceedings that began today?
Now, come again. My expectation of
the judiciary, based on the fact that a lot of Nigerians are looking at the details, perhaps for the first time more critically than we've ever seen, on the proceeding in the Presidential Election Tribunal. What are your expectations? What do you think that the judiciary should be looking into in dispensing justice in this matter?
I think the presiding justice, the Honorable Justice Amani, they made the point today that the court will not give room for undue technicalities or crass legalism. I think that is commendable. I'm very convinced that justice will be done. The parties will have to adduce evidence to support their claims. And once that is done, of course, the respondents will also challenge the evidence of the petitioners. And once that is done, I'm very convinced that justice will be done.
Let me take you to the economy matter, because when I saw that statement, I was worried. You have alleged economic sabotage between the Central Bank of Nigeria and the likes of the IMF. Is this a deliberate economic sabotage of some persons to have a dollar domination on Nigerian economy? And what are the consequences? Is there any major danger to the Nigerian people?
Sean, just before I attend to your question, I wish to react to the claim of Senator Ifeanyi that it should be credited, it should be commended for the amendment of Deep Offshore Production Contracts Act with profound respect. I started that campaign in 2015. The records are there. By 2019, I submitted, with the assistance of Dr. Clinton Jaja, I drafted a bill for the amendment of that act. And the bill was adopted by the Senate under the presidency of Dr. Bukola Saraki. But the Senate could not complete the exercise. Hence, the current Senate had to, pick up the battle where it was left. So I drafted the bill. It was the bill that was adjusted by the current Senate. So I don't think it would be fair. Just to put the record straight. Now, coming back to the dollarization of the economy, I have been fighting the current leadership of the central bank for turning the Nigerian economy into a kalo-kalo affair. The central bank is superintended, is supervised by the IMF and World Bank. And their position, the position of the Bretton Woods institutions, is that the Naira is overvalued and that the Naira should be completely destroyed. The central bank supports such neoliberal, very dangerous neoliberal policy. And that is why Section 20 of the Central Bank Act, which provides that the legal tenders in Nigeria shall be currency notes issued by the central bank as well as coins. But today, the dollar is spent in Nigeria. Landlords collect rents in dollars in certain parts of the country. School fees are paid in dollars. And I have fought the central bank. Under what law have you allowed people, the economy to be dollarized? And the central bank has pleaded with me, oh, we are going to react to your position very soon. And that's taking some months. Now, what I'm now saying is that the world is moving. Along our campaign, the BRICS, and I'm talking of Brazil, India, South Africa, China, and India, BRICS, that body is now campaigning that it is going to have an international currency to challenge the dollar. About 24 countries have applied to join the body in their next summit that will take place in South Africa. I'm simply asking, what is the position of Nigeria? Have we reduced ourselves to the footnote of history as far as international affairs are concerned? When you look at Section 19E of the Constitution, it provides that it shall be the duty of the government of Nigeria to promote a new international economic order, and that is the one before us, i.e., that we have no business selling our oil and gas and other products in dollars. No business. We are supposed to ask the buyers to pay in Naira so that you can show up your currency. And that is what Russia is doing currently. China is doing the same currently. India is doing that. They are trading in rubles and rupees. And why can we not trade in Naira?
Mr. Falano.
5 years ago. 5 years ago. Yes, please.
Yeah, I wanted to jump in to say, now, the Dangote refinery, we understand that we officially get off the ground, it will start operations, and President Buhari will probably be on that ground to commission it. That's some good news, especially for the consumption of oil. Now that you've mentioned it, most of the monies that we spent in Nigeria as a government is also on this importation and exportation of crude and bringing it back into the country. Now, what would you be, because Buhari is going out, Tinubu will be coming in. What do you think is most important, especially for the government that is coming in this very matter that is troubling?
You see, before the Buhari regime goes, it is important to let Nigeria know that we have investment in the Dangote refinery. Nigeria invested $2.7 billion in that refinery. In addition, 300,000 barrels of crude oil will be given to the refinery per day. The agreement has not been published, but those are the highlights. Secondly, the Buhari administration very belatedly had earmarked $1.5 billion to fix the Port Harcourt refinery. We understand the refinery will come on stream this year. For Warri and Kaduna refinery, the government has also paid contractors $1.4 billion. Now, when these refineries, are turned around, and then with our investment in the Dangote refinery, I believe that the incoming government will have to set up an inquiry to find out why the government claims to have spent trillions of naira on importation of fuel, and that the bulk of the fuel imported is smuggled out of the country. But the Comptroller General of Customs, Colonel Hamid Ali, has said publicly that it is not possible for the bulk of 68 million liters of petrol to be smuggled out of the country daily. But you will need about 2,000 tankers to do that anyway. So the government will need to investigate the monumental fraud.
All right. Mr. Falano.
That has been our loss.
Yeah. So I'm being told I just have less than 60 seconds to go. Well, I mean, you raise a very fundamental issue here, Mr. Falano. Just in about 60 seconds, please. What would be your final thought on this, and perhaps what we urgently need to do?
I'm advising the government of Nigeria as soon as possible to join the BRICS, to apply to join the BRICS. Secondly, we must revive the currency swap between Nigeria and China that allows Nigerian business, men and women, to buy goods in China, in Naira, while Chinese will also buy goods in Nigeria, in yuan. Now, in addition to that, Kenya has just signed an agreement with Aramco in Saudi Arabia to pay shillings for fuel imports. Kenya was spending $500 million per month to buy fuel, petrol, diesel. Now, that country has been allowed now to pay in shillings. We are also saying Nigeria selling oil and gas must now tell the buyers, pay naira to us and not dollars any longer.
All right. Mr. Falano.
That's our product.
Yeah. Thank you so much indeed for your time tonight. And
Thank
I
you very
appreciate your intervention and your advocacy. And I hope somebody is listening. It is going to be in the interest of the Nigerian people. Thank you so much, Leonard Sik, for your time tonight and your industry.
Thank you very much.
I appreciate it. Thank you so much.
Pleasure.
Indeed.
If you enjoyed this video, don't fail to subscribe and put a comment on the comment box on notification for everyone to see. Thank you very much.